day to our respected lecturer and fellow viewers. We are Group 2. Before we present our discussion, let us first introduce ourselves. Me, Nur Zafira Izati binti Zainul. My metric number is 306664.
My name is Lydia Lenya Anna Mekle. My metric number is 306950.
My name is Nurzawani Kistina, and my matrix number is 297323.
My name is Adila Wajaha binti Muhammad Fauzi, metric number 305170.
My name is Nurul Nakisha binti Nozan, metric number 303612.
Okay, today we're diving into a fascinating area of tort law that hits close to home. In our neighborhood, we often live by the give and take rule. But what happens when one neighbor takes a bit too much? Our case study only today involves a dispute between Akil and his neighbor Mr. Wong, centered around a massive unmanaged mango tree. The issue is focusing on tort of private nuisance. Let's explore through the meaning of private nuisance. Private nuisance is a civil wrong. It is the unreasonable, unwarranted, or unlawful use of one's property in a manner that substantially interferes with the enjoyment or use of another individual's property without an actual trespass or physical invasion to the land. It may be defined as an unlawful interference with a person's use, comfort, enjoyment, and any interest that a person may have over his land. It is the unreasonable use of man of his land to the detriment of his neighbor. The law recognizes that landowners or those in rightful possession of land have the right to unimpaired condition of the property and to reasonable comfort and convenience in its occupation. That being said, as we explore this case, we aren't just looking at a simple gardening disagreement, but we're looking at how the law of private nuisance balances the rights of property owners. Is a tree owner liable for natural growth? Does rotting fruit count as legal interference? To answer these questions, our group will be analyzing the latest judicial trends from 2020 to 2025, including major decisions like the UK Supreme Court's case Fern against the Tate Gallery and local Malaysian presidents. Let's start by looking at what actually happened on the ground.
Let's set the scenes. Akil and Mr. Wong are next door neighbor. For 2 years, Akil has watched Mr. Wong's large mango trees transform from a garden feature into a major problem. The tree's branches have crossed the boundary fence, hanging directly over Akil koi, pond, and patio area. But it's not just about the shade. As the tree matures, it's raining down debris, leaf, and heavy mangoes directly into Akil's pond. These mangoes, it rot quickly, which creating a foul stench, and it's attracting a small army of ants and insects. It has become so unhygienic that Akil and his kids can even use their own outdoor space safely. On top of that, the falling leaves have clogged the pond filtration system, leading to real repair bills for Akil's. Akil did the right thing. He spent a year politely asking Mr. Wong to trim the tree. However, Mr. Wong was completely dismissive by telling Akil that the trees grow naturally and he should just clean his garden more often. This lack of consideration is what brings us to the courtroom today.
Now let's move on to the issues that arose in this case. Based on these frustrating facts, we have identified three core legal issues that our group must resolve to advise Akil on his next steps. First of all, we must ask, does the encroachment of the branches and the resulting debris constitute a substantial interference? We need to determine if it goes beyond the mere annoyance into the realm of legal damage. Second, does Mr. Wong's refusal to manage his tree despite being repeatedly notified amounts to unreasonable conduct? We will look at whether natural growth is a valid legal defense or just as excuse for neglect. And third, If liability is established, what remedies can Akil seek? It is enough for Mr. Wong to pay for the filters, or can a court force him to cut the tree back via an injunction?
So, to provide legal advice to Akil, we must first establish the legal framework of private nuisance. As defined in tort law in Malaysia, private nuisance is an unlawful interference with a person's use, enjoyment, or interest in their land. It essentially governs how neighbors must balance their respective rights to use their property. The court uses a two-limb test to determine liability, that is substantial interference and unreasonableness. Under the first limb, the interference must be more than a mere annoyance, meaning it must be significant in nature. The law distinguishes between two types of substantial interference, that is, material physical damage and interference with use, comfort, or amenity. Material physical damages involves tangible harm to the property. In the case of Goh Chat Ngi and three others, and To Hian and another, where construction work caused cracks, uh, in a neighbor's house. Interference with goods, on the other hand, occurs when a defendant's activities cause discomfort that prevents a plaintiff from living peacefully. In the case of Dr. Harnam Singh and Rina Ling Senior Berhad, the court found that ongoing noise and traffic issues constituted a nuisance because they unreasonably impacted the plaintiff's enjoyment of their property. A landmark case of Fern and Board of Trustees of Tate and Gallery. The court held that intense visual intrusion from a viewing platform was a substantial interference because it forced residents to alter their daily lives and ordinary use of their homes. This applies directly to Akil, whose family can no longer safely use their garden due to rotting debris and insects.
Now, let me explain further. The second limb of our test is unreasonableness. This is a balancing act where the court weighs the defendant's right to use their land against the plaintiff's right to quiet enjoyment. Several factors determine reasonableness, most notably with duration and frequency of the interference. In IJM Corporation Berhad and Harta Kumpulan Sendirian Berhad, the court emphasized that for an interference to be actionable, it perfectly must be continuous rather than a one-off event. We must also look at recent Malaysian precedents to see how our courts balance these interests. In the case of Ranjan Paramalinam and another, and Persatuan Penduduk Taman Bangsa, the federal court reminded us that not every discomfort is unreasonable. If an interference is deemed reasonable within the local context or provides a community benefit and the plaintiff lacks solid proof of excessive harm, the claim may fail. Crucially, in the case of Wong Tak Meng and Top Solid Portfolio, Sendirian Berhad highlights the importance of causation. The High Court dismissed that claim because the plaintiff could not prove on a balance of probabilities that the defendant's action directly caused the damage, especially when natural factors like heavy rain were involved. Finally, the 2025 case of Nicholas and Thomas confirms a vital point for Mr. Wong stated that even natural use of land, like growing trees, can become a nuisance if they are persistent, harmful, and the owner ignores repeated requests to mitigate the harm. Now that we have established these high-level principles and reasons authorities, let's apply them to the specific facts of Akil disputes with Mr. Wong.
That's correct, Nakisha. As we have highlighted the relevant law and decided case to determine Akil and Mr. Wong disputes, therefore I can say that it is clear Akil has satisfied both essential elements required to establish liability, namely substantial interference and unreasonableness of the defendant's conduct. First, Akil must prove that Mr. Wong conduct cause substantial interference with his use, comfort, or enjoyment of land. In this case, Mr. Wong mango tree has grown extensively over a period of 2 years, with its branches crossing the boundary fence and encroaching directly into Akil's gardens. This is not a minor or occasional convenience. The mango tree has continuously shed leaf sapped and ripe mangoes into Akil Koi Pond and patio area. The fallen mangoes rot quickly, creating unpleasant smell and attracting an insect which make the outdoor space uncomfortable and at times unsafe, especially for Akil's children. As a result, Akil and his family are unable to fully use and enjoy their gardens in a normal and peaceful manner.
This situation closely reflects the legal principle established in Dr. Harnam Singh's and Rinaleng KL Sendirian Berhad, where the court recognized that outgoing discomfort, such as persistent noise and invasion of privacy, could amount to actionable nuisance. In that case, the defendant's activities were considered beneficial to the public. However, the court held that public benefit does not excuse substantial interference with the neighbor's enjoyment of land. This demonstrates that the law prioritizes the protection of individual property rights when interference becomes continuous and unreasonable. Similarly, in the present situation, the fact that trees are natural or not intentionally harmful does not negate liability for nuisance. The court have consistently emphasized that the focus lies on the effect of the defendant. Even lawful or natural activities may give rise to nuisance if they result in substantial and ongoing disturbance to a neighboring occupier use and enjoyment of their property. Therefore, the constant unpleasant smell, proliferation of insect, and resulting hygiene concern go beyond mere trivial annoyance. These conditions significantly disrupt Akil's comfort and peaceful enjoyment of his land, satisfying the threshold for amenity nuisance. Given the continuous nature and severity of the interference, Akil will likely to be able to establish that the disturbance is unreasonable and actionable under the law of private nuisance.
Apart from discomfort, Akil also suffers material and physical damage, which further strengthen his claim of substantial interference. The continuous fall of leaves into Akil's koi pond has caused the pond's filtration system to clog, forcing Akil to incur additional maintenance and repair costs. This constitutes actual physical damage to property rather than a simple inconvenience. This is comparable to Goh Chat Ni and three others against Tohyan and another in 1991, where cracks in the plaintiff's house were considered material damage and sufficient to establish private nuisance. In acute cases, the damage to filtration system is tangible, measurable, and recurring, showing that the interference is substantial in nature. Furthermore, similar to Fern against Board of Trustee of Tate Gallery in 2023, Akil is effectively forced to alter how he used his land, while the resident in the Fern had to close curtains and avoid certain rooms. Akil and his children are unable to freely use their outdoor space due to hygiene risks and safety concerns. This shows a real and significant impact on ordinary land use. In the law of private nuisance, material and physical damage represent a higher tier of interference than personal discomfort, such as noise or bad smells. When a neighbor's action lead to actual physical harm to your property, your legal position becomes significantly stronger.
That's right, Lydia. The second main element Akil must establish is that Mr. Wong's conduct is unreasonable. There are few factors that the court will consider in determining whether or not a particular use of land is reasonable. One of the relevant factors is that the duration of interference must be continuous. To be actionable, a nuisance must occur repeatedly or over a period of time, not merely as a one-off incident. In IJM Corporation Berhad against Harta Kumpulan Sendirian Berhad, the defendant's building activities led to cracks and harm to the plaintiff's property. The destruction persisted during the entire building phase. The court determined that a private nuisance existed. This case demonstrates that because of the continuous nature of the disruption, it was not it was not merely a single event. Consequently, the harm escalated as time passed. Although landowners are generally entitled to use their land property as they wish, this right is not absolute. It must be balanced against a neighbor's right to quiet enjoyment. Here, Akil has repeatedly and politely requested Mr. Wong to trim the tree branches over the past year. This means Mr. Wong had actual knowledge of the problem. Despite, he dismissed Akil's concern and took no steps to prevent the ongoing interference. They show a lack of reasonable care and consideration. Unlike cases where the defendant take steps to minimize harm, Mr. Wong chose to do nothing, allowing the nuisance to continue. His response that tree grows naturally does not justify ignoring foreseeable harm to his neighbor. Mr. Wong's dismissive attitude and total lack of effort to mitigate the risk demonstrate a lack of reasonable care for his neighbor's property right. This distinguishes Akil's case from Ranjan Paramalingam and Persatuan Penduduk Taman Bangsa, where the court found the interference reasonable due to community benefits and lack of strong evidence. In contrast, Akil has clear evidence of harm, and the interference serves no strong evidence. In contrast, Akil has clear evidence of harm, and the interference serves no broader public interest.
Next, Akhil can clearly prove causation between Mr. Wong's conduct and the damage suffered. This can be seen in the case of Wong Tatman and Top Solid Portfolios in Berhad, where the plaintiff claimed that wastewater discharge from the defendant's fish ponds through pipes and waterways caused flooding, soil erosion, and damage to fruit trees on his neighboring land, amounting to trespass and private nuisance. However, the High Court dismissed that the claim because the plaintiff was unable to demonstrate on the balance of probabilities that the defendant's discharge could have caused the flooding. In short, in this case, not all interference encountered are the same as the term of interference under the context of tort law, especially if there is no clear causal evidence, and it is stronger for the claim to be dismissed when there is no evidence that convinces the court that the damage is caused by the defendant's action. Thus, it is vital to ensure that there is physical damage and clear causal evidence to bring an action. Unlike Wong Tuckman and Top Solid Portfolio Syndrome Berhad, where flooding could have been caused by natural factors, the source of Akhil's problem is obvious and direct. The mangoes, leaves, and sap originate from Mr. Wong's tree and fall directly into Akhil's property. There is no intervening natural event or third party involved. Therefore, the causal link between the defendant's conduct and the plaintiff's loss is strong and convincing. In conclusion, Akhil can successfully bring legal action against Mr. Wong under the thought of private nuisance. The facts clearly establish substantial interference and unreasonableness supported by both Malaysian and recent international case law. Mr. Wong's failure to act despite notice strengthens Akhil's claim.
One important lesson that can be learned from this case is that the right to use one's property is not absolute. Although a landowner is generally free to enjoy and manage their land as they wish, this freedom is limited when it begins to interfere with a neighbor's use and enjoyment of their own property. In this case, Mr. Wong's mango tree may be natural, but once it causes ongoing discomfort, physical damage, and safety concerns to Akil, the law of private nuisance becomes applicable. Another key lesson is that private nuisance focuses on the effect of the interference, not the intention of the defendant. Mr. Wong did not intend to harm Akil. However, intention is not a requirement in private nuisance. What matters is whether the interference is substantial and unreasonable. This reinforces the principle that even lawful or ordinary activities, such as growing trees, can become actionable if they create continuous and serious interference. This case also highlights the importance of reasonableness and neighborly responsibility. Akil acted reasonably by approaching Mr. Wong politely and giving him opportunities to resolve the issue without legal action. Mr. Wong's refusal to take any steps despite being informed of the harm demonstrates unreasonable behavior. The lesson here is that ignoring a neighbor's legitimate concerns can strengthen a legal claim against oneself.
That's true, Zawani. Furthermore, the case teach that evidence and causation are crucial in nuisance claim. Akil's ability to clearly link the falling mangoes, leaf, and cloud filtration system to Mr. Wang tree distinguishes this case from others where claims fail due to lack of proof. It shows that plaintiff must be able to demonstrate a direct connection between the defendant's conduct and the damage suffered. Finally, this case illustrates that private nuisance law aims to balance competence land use, not to punish the landowner unnecessarily. The court does not prohibit trees or normal land use, but it ensures fairness by protecting individual from unreasonable and ongoing interference. Remedies such as injunctions and damage serve to restore balance rather than to penalize. That is the end of our discussions. Thank you very much and Assalamualaikum.